So I'd like to call this meeting to order. Good afternoon and welcome to our special council meeting on October 23rd, 2024. The purpose of this meeting is to receive information on education regarding the Code of Conduct from the Region's Integrity Commissioner. I will now call on Will Short to do the roll call.
Thank you, Chair Redmond.
Present.
Councillor Craig.
Present.
Councillor Deutschmann. Councillor Erb.
Present.
Councillor Foxton.
Present.
Councillor Harris. Councillor Huning. Councillor James.
Present.
Councillor Liggett. Councillor McCabe. Councillor Nowak. Councillor Solonin. Councillor Shantz.
Present.
Councillor Rabanovic.
Present.
Councillor Williams.
Present.
And Councillor Wolf.
Present.
Thank you, Chair.
Thank you, colleagues. I'd like to acknowledge that the land on which we gather today is the traditional territory of the Haudenosaunee, the Anishinaabe, and the Chinatan peoples. In doing so, I want to reflect on what it means to be doing important community work like we are engaging in collectively today, and also on my own individual relationship to this land. As a settler, one of the most important aspects of my individual journey towards truth and reconciliation has been to listen, and I am continually grateful that the community continues to share their stories and their concerns with me. As well as chair of the region, I know that I carry a large responsibility to ensure that it is not just myself on an individual level listening and acting, but that as a government, we are listening and creating action within the community. I'm offering this acknowledgement as one of the many actions I am personally, and the region largely, is taking on to our journey towards reconciliation. We acknowledge the enduring presence of the Indigenous people with whom we share this land today, their achievements and their contributions to our community. Are there any declarations of pecuniary interest under the Conflict of Interest Act? Seeing none, we will go to our presentation, and I would like to welcome our Integrity Commissioner, John Mascaron from Aird and Burles, to provide a presentation on municipal codes of conduct and the roles and responsibilities of staff and council. The region's code of conduct was passed in 2018 and is due for an update. In the coming months, staff will be gathering feedback from council and presenting a draft code of conduct for our consideration. John is here to remind us of the rules around codes and our various responsibilities to set the background for this ongoing process. John, welcome, and the floor is yours.
Thank you, Chris. Good afternoon, Madam Chair, members of council. I'm John Mascaron, as was introduced by the chair. I'm your Integrity Commissioner, if you didn't know that. Some of you may not have reached out to me, and those who have, I thank you very much, because one of the unheralded benefits that you could have as a member of council is the ability to reach out to your Integrity Commissioner to get advice on certain matters. Today, I will be speaking to you initially about the Code of Conduct. Your code is a little bit out of date. I'll just be polite about it. It was a little bit out of date, maybe even when it was first created. It just wasn't of the vigor that I think it should be for a municipality of your maturity and stature. And so I've been working very closely with staff, and I really do want to thank the folks in the clerk's department who have been immensely of assistance to me in putting together a new code, which we will be bringing forward to you. A new code of conduct, which I would describe as modernized, contemporary, and in line with best practices that you will see at other municipalities. I do want to mention just one thing. On the weekend, I was reading, and Global News had an article about the Office of the Integrity Commissioner of Ontario providing recommendations to the Premier, or to the provincial government, on the new code of on the municipal accountability regime. As you know, the province has been rather lacking in going forward with its proposals. It 3 times looked at private members' bill to tighten up and to try to put some real teeth into the legislation to combat a number of things that are happening across the province. And 3 times the province has said, no, we're not ready yet. Minister Clark was almost ready 3 years ago to move forward and then aborted right at the very last moment. I was holding the meeting, the conference, the fall conference of the Municipal Integrity Commissioners of Ontario at my office, and I had invited Municipal Affairs to attend to talk about the new things that were coming forward, and the lawyer from Municipal Affairs had nothing to say because it was aborted at the last moment. Don't know exactly what happened. Minister Clark, of course, is no longer there. Minister Calandra has now twice promised to bring forward amendments, and the last time I looked, just before AMO, he said they were very complex. The Premier had reached out to J. David Wake, the province's Integrity Commissioner, with whom I have a great deal of respect, and Mr. Wake has made 9 recommendations. We don't know when they're going to be implemented, but the first one, and I want to be absolutely candid with you today, is a standardized code for all municipalities across the province. Now, this is completely shocking to me, because if you remember when codes of conduct were first pronounced and they were permissive for municipalities, the province said, look, we're giving you additional powers, additional authorities under the Municipal Act 2001. Concomitant with that is your responsibility to keep your house in order. So you have to create your own codes. So this is really interesting. We've got now walking it back, and because I think a number of municipalities have said, we'd like to have a standardized code. I am not certain that that's a great idea. But what I really, really want to impart to you today is, don't wait for it to come forward. We don't know when it's going to come forward or if it's even going to come forward. Your staff have put a lot of effort into the new code, which we will be bringing forward, and I would ask you to please consider that. So please think of this as a prologue to a further discussion that I think we will be having in the coming months when the Code of Conduct comes forward. So that's my prologue. I didn't want to go on too long about it. So let me just talk to you about codes of conduct. You'll see on the screen, a municipality shall establish a code of conduct. This is new by the Bill 68 amendments in 2018. Before this, it was strictly permissive. A municipality didn't have to pass a code of conduct or adopt a code of conduct. Now you do have to have one. Notice that in subsection 3 there, it says a bylaw cannot provide that a member who contravenes the code of conduct is guilty of an offense or required to pay an administrative penalty. What does that say to me? That says to me that this is a unique animal. And many people, and I admit, other integrity commissioners in the province will say to you, oh, a code of conduct is a policy. No, it is not a policy. Where do you see a policy where you get where you get a monetary penalty for doing something? You don't see it in policies typically. And if it was going to be a policy, wouldn't it have been included in Section 270 of the Municipal Act that mandates policies that a municipality shall adopt and maintain? It's not in there. It's in its own separate section. I always look at the Code of Conduct as not just a guideline. It's something that you have to strictly comply with, okay? So, of course, and look at subsection 4 there, the minister has retained onto himself, itself, the ability to prescribe certain subject matters. And it has, and I'll show you in just a moment. So now codes of conduct are not just permissive, they're mandatory for a municipality, and it's for the municipality's council and also for its members of its local boards. It's very clear. What we will bring forward to you is a single code that refers to a member as a member of council and a member of a local board. And I think that's completely justified, because shouldn't the same strictures that apply to you apply to any member of a local board? With, I admit, with some consideration that as a member of council, you're a member of council 24/7. Of course, some of you are also members of council at your local municipality, so you've got maybe 48-14, but you're going to be members of council at all times. The same stricture doesn't necessarily apply to a member of a local board. So there is a little bit of different treatment, but really, should a member of a local board not be treated the same way as you are? They're both accountable to the public, to the electorate of this municipality. So the region has adopted a code of conduct for members of council, but it's also adopted a separate code, which is different for citizen appointments to local boards, foundations, and advisory committees. I'm going to suggest to you, and I think your staff have agreed wholly, one code that applies to both. The same rules apply to both. And as I said before, in my view, the codes right now appear to just be policies, and that would be the wrong way of thinking. A policy is something that maybe you comply with, or maybe you don't. And that's not how you're supposed to think of a code of conduct. My good friend Gregory Levine wrote this really wonderful book, Municipal Ethics Regimes. He says, codes of ethics in the public sector are intended to promote integrity in public affairs and to provide guides to acceptable behavior. I've often said a code of conduct is not an encyclopedia. My good friend, Madam Justice Janet Leeper, whom we used to go around the province and talk about codes of conduct and how they work, she often used to say, it's not a cookbook. You can't look up the code and go, what's my fact situation and how does it work? It doesn't work like that. It sets out standards. It sets out prohibitions. It does so, admittedly, in broad language that, in my view, should be easy to understand. We've tried to put together a code for you that is credible, it's useful, and it is hopefully user-friendly, not only to you as members, to staff who might have to understand it, and to the public who may want to hold your feet to the fire on what's in the code. So here are the prescribed subject matters. They're in a regulation. There's gifts, benefits, and hospitality. Typically, most codes in the province set out the requirement like this. Your current code does. You are not allowed to receive any gift, benefit, or hospitality related directly or indirectly to what you do, to your official duties. If you think about it, that doesn't actually make total sense, because why? You receive compensation for your public service. So there you go. That's a gift, benefit, or hospitality, however you want to think about it. So typically, what a code will do is set out in absolute terms, you're not allowed to receive any gift, benefit, or hospitality. Usually, one of those terms is defined. You typically gift, and it includes a benefit or hospitality. And then there's a carve-out from that, and that's how we've set this up. There's a number of carve-outs. One is the volunteer service that you could accept from someone who is working on your re-election campaign in accordance with the Municipal Elections Act, for example. Another one is you receive a token gift as a note of appreciation if you were to attend a conference and speak at it. You, of course, may be entitled to keep that. Now, there are monetary limits to some of these things, which makes sense. You, as members of council, are probably pretty busy. You might have a constituent that would like to meet with you and talk to you. You may only be able to meet with them for a coffee in the morning, or perhaps a quick bite to eat at lunch. Is it wrong for you to accept perhaps their hospitality? Say, councillor, you're taking up your time. I'd like to pay for this Tim Hortons lunch today. My view, absolutely not. If someone thinks that your integrity can be bought by a Tim Hortons lunch or even something moderately more expensive, I would say that's a bunch of kerfuffle. That's wrong. Of course you can accept something, and there are limits, and we've put that in. So that's gifts, benefits, or hospitality. The second one is something that I'll spend, I think, a little bit of time talking about this afternoon when I speak to you about roles and responsibilities. Respectful conduct. but it's not respectful conduct, period. Notice that. This is the actual wording of the regulation on the screen. Number 2, respectful conduct, including conduct towards officers and employees of the municipality or the local board, as the case may be. The province made a deliberate choice here, not just to say respectful conduct, because if it had said respectful conduct, what would you have thought of? You would have said, okay, I need to be respectful with everyone I deal with other members of council at the council table or even beyond, with members of staff, clearly, and with the public, or any consultants or people who come to speak at the municipality or do business with the municipality. But the province thought it fit to go further. Respectful conduct, including conduct towards officers and employees of the municipality. Why would it do that? I'll tell you why. Because there's a problem. Many municipalities, many council members do not treat staff with respect, treat them as second citizens. This has become a pervasive problem throughout the whole province, where you see this happening over and over again. I'll give you an example. Member of a resident comes forward and all of a sudden says, well, you know, your staff's not doing a good job. Okay? Now, maybe the resident is saying that because they have a vested interest in a particular matter, okay? All of a sudden, has staff been doing something wrong because a person may have said staff isn't doing their job? Maybe, maybe not. But what shouldn't happen is shouldn't be a call out at a public meeting to criticize staff. Now, I'll speak a little bit more about it because there's a case that's right on point from the Ontario Divisional Court, and I will talk about it. Number 3, confidential information. Probably one of the biggest sources of complaints that we get as integrity commissioners, and I maybe should have said this at the beginning. My firm acts as integrity commissioner for maybe about 75, 80 municipalities across the province. We have a lot of larger municipalities. We have many small municipalities. We have municipalities in between. Upper tier, lower tier, single tier. And one of the greatest sources of complaint, apart from not respectful conduct, is confidential information. And I will speak about that in a moment because there's an actual Ontario Divisional Court decision on that topic as well, right? There are 3 sources of confidential information that you will receive as members of council. The first source is information that's protected by legislation. MFIPA, PPIDA, the Public Health and Information Protection Act. I'm not sure if I've got that one right. But there are sources where you cannot disclose personal information about persons, right? What's the other source? Closed meeting council information. Information is given to you at a certain period of time for the members who attend that meeting to make a decision, to take action, to give an approval, to not give an approval, to give directions to staff. That information is given to you as members of council, and it's given to you confidentially. It's imbued with confidence. It's in your code of conduct. It will be in your new code of conduct. It is incredibly wrong for you to release confidential information to other sources. That could create damage, injury, liability, loss of reputation in the municipality. That's why it's a mandatory prescribed subject matter. The fourth one is the use of the property of the municipality. And if you're looking at this, property does not only mean real property. The word is property. If you look at the Municipal Act, if the province intended to say real property, it certainly does so. If it says property, it means property writ large. Personal property, real property, and intellectual property. Did you know that the logos of a municipality, the branding of a municipality, your insignia, that is an official mark of the municipality. You're not allowed to use that outside of your role as a member of council. My first ever complaint that I ever got was against, and I can say it, it's a public matter, the mayor of Innisfil. She used her mayor photo for re-election purposes, and it showed the chain of office. She doesn't own the chain of office. It doesn't belong to her. It belongs to the municipality. She was aghast. She said, I didn't think this was property. I go, it's property. It's property of the municipality. You can't use that. Now, I didn't go hard on her because she admitted it right away and she publicly apologized. And so my ultimate report was that there was a contravention, but she made amends immediately upon finding out that I believe that it was an error for her to do that. So property is writ large there. So please just keep that in mind. And as I said, the minister may make regulations prescribing one or more subject matters. To date, only the 4. What is really important that you're going to see coming forward, we've tried to put some real robustness to the complaint protocol that we have. What is a complaint protocol? It is something that's so important that the Ontario Divisional Court in DiBiase versus Vaughan said it is part of the statutory scheme. It's as important as the Code of Conduct, Part 5.1 of the Municipal Act, that is the accountability and transparency provisions, and the complaint protocol. It's important to that extent. What it does is it sets out a process and procedure for how a complaint may be filed and how it may be reviewed and investigated by our office as the Integrity Commissioner. It establishes ultimately a process that is fair and equitable to all parties. The courts have said very clearly what the Integrity Commissioner has to provide in a complaint process, in an investigation, is a fair process to the member who's being accused of some wrongdoing, but also to the complainant and any witnesses. So, what does a complaint protocol entail? Things like, how do you file or submit a complaint? Do you have to use a particular form? We are recommending certain forms have to be used. I will tell you, it's extraordinary how many times we get complaints. And typically, they will name who the council member is that they're alleging did something wrong. But I'll tell you, I've actually received 2 complaints where they didn't even name the council member. So, interesting. But typically, it won't say much. It'll say, council members acting inappropriately has done so all term and we want you to go find out. That doesn't work that way. We'd like to know what particular provisions of the code are you alleging have been breached and by what acts, right? So we tried to set this out in a user-friendly form to guide the persons who are coming forward so that they'll have some indication of what they have to show us. And we typically have something in the complaint protocol that says you have to put your best foot forward. What you can't do is say, the council member did this on this day. And then as we're investigating, oh, by the way, they did it again. Oh, and they did it a 3rd time. That's not fair because we've put one allegation to the council member. We have to stop the whole process, go back. So we have something in there that says the complainant must provide a full record of what the allegation is. Now, I will be the first to admit, yes, something could happen on a particular day and something could happen again. But as a complainant, you have to understand it has to be fair to the member. You have to put the allegations to the member, who then has to see what the evidence is and be able to respond. And if you're getting new allegations, it would be completely unfair if we didn't come back to you. But you can imagine how this could ping-pong back and forth, and it could take years for this matter to resolve. So we try to put some finality, and many times we have to go back to complainants and say to them, you know what, we're stopping this now. Like, if you're going to file anything further, we're going to have to just stop, right? One of the big chores that we had, which I didn't ever expect having, is when complaints are filed, you don't even really know what it's about sometimes. So we don't actually treat the complaint as having been effectively filed with us until we actually know what it's about, because many times we have to go back to the complainant to get clarification, get an understanding. And yes, sometimes assist them to understand the process. The Ontario Divisional Court, again in the DiBiase versus Vaughn's case, has been very clear. An integrity commissioner can take a complaint and can reformulate the complaint. That's pretty big authority there. We do not reformulate complaints at my office. But what we do is we go back and we ask the complainant, could you please clarify? Could you please give us an understanding? You've said something's happened. You need to tell us what date, were there any witnesses? Do you have any evidence, right? So all of that it will be in here. So the form, I hope, will help. We do an intake and review procedure. When a complaint comes in, there will be someone who will review it and decide, is this even a matter dealing with the code of conduct? I'll give you an example. We got one just last night. Complaint came in and said, I'm very upset at the way 3 council members voted to do this. They voted. One of your main roles is to go to meetings and vote. What they're really upset about is the decision of council. Shirelli versus City of Ottawa says very clearly, the Integrity Commissioner does not look at decisions of council. There are other ways to challenge the decision of a council. There could be an appeal, Planning Act matters. There could be an application to quash under the Municipal Act, a judicial review under the Judicial Review Procedures Act, or a myriad of other potential challenges to what council has done. We, as an Integrity Commissioner, do not look at the decisions of council. So we do an intake. We often look at it and we go, I think what they're alleging here is defamation. That's a private civil tort. We're not going to look at that. Now, if it's disrespectful conduct that may border on defamation, that's a whole different thing. But if it's just something different, we will refer them on. There's a privacy breach. That is something that the Information and Privacy Commissioner will look at, not the Integrity Commissioner. Ergo. So we will do that. We've built into the complaint protocol something that is recognized in the Legislation Act. But people don't understand this. You can appreciate a member of a resident comes forward with a complaint. They probably believe that it has some validity. Can you imagine how they feel if we say to them, we're closing our book on this because we're summarily dismissing it. We don't believe it even meets the test, the threshold, for us to even do an inquiry. They're not very happy about that. And they typically come back, where do you get the authority to do that? The authority is not in the Municipal Act, it's under the Legislation Act. The Legislation Act, any person who has been given the authority, delegated the authority to do something, has the authority to do everything related to that matter. That would include looking at a complaint, considering it, giving some thought and saying, I don't think this has anything to do with a proper valid complaint for which we have to spend public money to go and investigate. So summarily dismissed. We have that. We have it right in the code, so anyone who's looking at it will see it. So we don't get these calls saying, you didn't do your job because, you know what, you're a lapdog, you're not a watchdog. And we've gotten that many times. But just imagine us going away and having to do an investigation every time a complaint's been filed. And yes, we do have some municipalities that have codes that actually say that. It's really wrong, because then they say to us, how much does this investigation cost? We go, we wouldn't have even had to do it, but your code requires us to do it. Okay, so there's that. It talks about evidence gathering. How fair would the process be if someone could file a complaint and we wouldn't tell you about it at all, and we'd come back to council with a report saying you're in contravention? That's not a very fair process, is it? So we have all kinds of clauses in the complaint protocol that talk about what type of rights does the member have. The member has a right to respond, clearly. Do you have a right to know the identity of the individual who filed the complaint? Typically not. Typically, the first question we get asked is, who filed this? And we typically say, we're not telling you. What complaint system normally would identify a complainant? Just imagine the chaos. And it leads to things like reprisals that you don't want to get involved in. There's an interesting battle right now in Greater Sudbury. The municipality has said, our code is going to be changed, and we're going to put in a code that says you have to identify publicly who the complainant is. Their integrity commissioner said, good luck with that, because I'm the integrity commissioner, and we have to keep everything in confidence. He's saying, I'm not going to accede to that. That's an interesting battle that I'm going to be watching, because I've had that battle with a few municipalities. Now, you can say, if someone's really, really angry and they want to put forward a complaint, they should put their name behind it. I understand that, but I think it would have a huge chilling effect, and I don't think it's warranted. The Ontario Ombudsman has been very clear. That is so wrong. You are not to identify complainants. The Ontario Ombudsman never does, in closed meeting investigations and otherwise. We always provide either preliminary findings or a draft of our final consideration of the report to the member if we find that the member has contravened the code. Why? Because that is the last opportunity for the member to actually try to convince us otherwise. The member may get the complaint, right? You may get a complaint. You may look at it. You may say, I don't think this is worth too much, and you might file submissions. But you don't know how we'll treat those submissions. We could potentially just agree with the complainant and say, we agree with the complainant, we don't agree with the member. Would it be very fair if we brought a report to council and you wouldn't have an opportunity to know what our preliminary findings are? In my view, that wouldn't be a fair process. We always do this. We always give a final draft of the report that we propose to bring to council to the member and say, here are our findings. Tell us what you'd like to do now that you know what our findings are. And at that point, we might get oh, I better really file something with you, right? Why do we do that? The Ontario Ombudsman does the exact same thing. Because the law is this: when a report is brought to council from an integrity commissioner, in two cases, Asselet versus Hawkesbury and Jonker versus West Lincoln. Full disclosure, I had involvement in both cases. The Ontario Divisional Court has said very clearly, the council cannot question the findings of an integrity commissioner once the integrity commissioner brings forward the findings. So my involvement is, I argued the case on behalf of the Integrity Commissioner in Hawkesbury, and the court said very clearly, the Integrity Commissioner is the person who has the authority to make these determinations. Council doesn't make a determination whether there's a contravention or not. Council does make a decision. Your role is to make a decision on the recommendations, which may include a penalty or a remedial measure or any corrective action. The Jonker case was a case where we decided that a member had acted inappropriately by leading the trucking convention, the contingent Niagara region convention of truckers in the Ottawa protest, which was deemed to be an illegal gathering by the federal government, provincial government, and the city of Ottawa. And he went on TV, made a number of comments, and was actually shown as Councillor Harold Jonker. He couldn't do that. We found that he contravened the code. He took us to court. The court ultimately said the Integrity Commissioner has the authority to make these decisions, make these determinations. Council can't question those determinations, can only decide whether to impose a penalty, not impose a penalty, impose a remedial measure, or not impose. So that's why we give a draft of the final report to a member of council to have a final opportunity to have them say, have we been convinced? Yes, we have. We've changed our opinion a few times. We've heard then a very cogent, succinct, persuasive argument, and we've changed it. Sometimes we haven't changed it at all because it's just the rehash of what we've already heard. But there's an opportunity there. How is the report then completed and transmitted? And How does council consider it? Your code has something extraordinary in it. It basically says you get the report and then you have 90 days to make a decision. Let me ask you, do you really want these things to fester for that long? You want to rip the Band-Aid off. If it's a bad thing that's happened, you want to make the decision. You want to start the reparation process immediately. Make the decision and move forward. Don't let it fester. In the code, and again, I want to be respectful to council. It's your code. You can change it. My recommendation, strong recommendation, is a report is brought to council. It's dealt with the same evening, the same day as the meeting. You don't defer it. You don't let it fester. And what you can't do, though, you can't leave it and adjourn it sine die, defer it till it's never heard. That's just not providing justice to what's happened. So let's just talk about a little bit what goes into the code. What did we think about when we were putting together this code? We talked about and considered what is the role of the counselor, right? So you have a number of different roles here. There's the regional counselor, a regional chair, there's individual members, and then there's regional or local board staff. Remember, code of conduct only applies to members, not staff. It doesn't apply to staff. You can have a code of ethics, a code of conduct for your staff. Not my purview, but you can have that, but that's not what this is. This is a code of conduct for members of council. So, Ian Rogers from the Law of Canadian Municipal Corporations, first written in 1959, then significantly revised in 1972 and carried on. Here's the basic role of a council member. While serving on the council, members are under a duty to act in the best interest of the corporation and the citizens they represent. And if you're going, hold on, the corporation and the citizens, just look at the definition of municipality in the Municipal Act. What does it say? Municipality means a geographic area whose inhabitants are incorporated. So you owe your obligations, your fiduciary obligations, to the electorate broadly, and to the corporation of the regional municipality of Waterloo. So, regional council, governing body is council, the most important decision-making body at the local level. Exercises executive and legislative functions. 98% of what you do is that. Sometimes, though, you act as a quasi-judicial tribunal. Very occasionally, I'll give you one example. There's a complaint under Section 20 of the Development Charges Act. The complainant comes to council. Council sits as an administrative judicial body to make a decision in that case. Council is an elected assembly, and it acts as a collective body. How does it do this? Typically by majority vote. That is our democratic process, except now that it's been derogated from by the strong mayors legislation, but I won't get to that too much today, okay? And how do you act? Bylaws, resolutions, approvals, and direction. Typically in a public forum, sometimes at a closed meeting. That's how you can give direction to staff, right? The role of council, here it is, in Section 224 of the Municipal Act. I'm not going to spend a lot of time. It says what it says, right? This is not the most important case in the world. Guelph University Village case versus Guelph. In Ontario, the decision-making power of municipalities is given to municipal council, and it is to exercise those powers by bylaw. Not totally correct. If you look at Section 5.3, it says, by bylaw or as otherwise specifically authorized. And I was actually in court last year arguing just that. The other side brought forward a case from 1967, which I thought was really cute, saying, you know, a municipality has to have a bylaw. That's not the law. Section 5.3 says, or as otherwise specifically authorized. Just think about that. That means in camera, when you go in closed session, what are you allowed to do when you vote? You are allowed to vote. You're allowed to vote if what? One, you're in camera on a proper matter. And two, it's for a procedural matter or for giving directions to officers, employees, or agents of the municipality. And I once had to kind of go to battle with the closed meeting investigator. in Kingston, I can name it because it's all public, who said, you need a bylaw. You need a bylaw. Council did not authorize this. And by the way, you can't make substantive decisions in closed. I see everyone's jaw dropping. They go, what? We can't make, this is for the people who are watching on camera. The jaws did not drop, but people are looking at me. You can make a substantive decision in camera. And yes, there are still closed meeting investigators that will say to you, you can't do that. What they do is they look at the words for a procedural matter and they go, it doesn't say for a substantive matter. That's an illogical conclusion. Let me ask you, how can you possibly give direction to your CAO, your treasurer, your clerk, your regional solicitor, unless you've made a substantive decision on what you're instructing them to do? So let's just pick on Fiona McRae, your regional solicitor. I'm sorry, Fiona, but you're going to instruct Fiona, who's giving you confidential information on a litigation matter. And she said to you, Counsel, I'm recommending to you that you should settle this matter, and I suggest this is the amount. Are we saying that you can't do that in camera? You can't give her instructions? Because to give her instructions, you have to actually make a substantive decision that you can give her instructions. You are allowed to do that, okay? So anyway, long diatribe about how the first paragraph is slightly wrong. But look at the second paragraph. The council is the general agent for all purposes, and it is the means whereby the municipality may bind itself to a course of action. What that is what the Supreme Court of Canada has said. The indoor management rule does not apply to municipalities. What's the indoor management rule? The indoor management rule is a rule for business corporations. And it says, if you're an officer or director of a business corporation, you may be entitled by statements that you make, actions that you take, to actually bind the municipality. That does not apply at the municipal level. Any member of council here cannot go and bind the municipality unless the municipality's council, regional council, has said so, unless the authority had been delegated to you somehow. The chair can't bind regional council except in some very limited circumstances. The Emergency Management Civil Protection Act, yes, and Madam Chair, as you probably know, you can expel someone from council. You don't have to ask anyone to do that. Otherwise, even the regional chair doesn't have the authority to bind council. Only council can do that. This is an important concept. So, sorry, here it is. Section 5.1. The powers of municipality exercised by its council, not individual members. How's the power to be exercised? By bylaw, unless the municipality is specifically authorized to do otherwise. Will, I'm going to put you on the spot. You have a confirmatory bylaw at the end of each meeting, right? There you go. Good practice. I go and speak to clerks and treasurers all the time, and I say, you have to have a confirmatory bylaw, and some of them go, we don't have one. I go, we'll talk later. That's a real problem if you don't have one. Because why? Most of your council meetings will proceed by way of a resolution that then get technically enshrined by a bylaw at the end, okay? So, council as a whole is the directing mind of the municipality and not its individual members. This is, at its foundation, incredibly important for you to know. And this is why the Code of Conduct is written in the way it is, okay? Look at the very last line. Council members must not seek to wield that power unilaterally or away from the council chambers. Because why? Your power resides in being in the council chamber and making a decision with quorum present that a majority of you have assented, not individually, okay? So just very briefly, the head of council, in this case, the regional chair Redmond. There she is. That's what her role is, okay? Presides over council meetings so that its business can be carried out effectively and efficiently. I can't believe how many people just fail to recognize that. You know, I always say you have to have a strong chair. The chair sometimes has to cut people off. The chair has to make rulings. There are really bad chairs around the province, right? People who don't do this. One of the main roles is to run meetings efficiently and effectively, okay? But look at the number one, Chief Executive Officer. What the heck does that mean? It doesn't mean that it's a Chief Executive Officer in the business context case. There is an actual reference to it. I've always said, I think this is a misnomer. I think it was a really bad idea to refer to the head of council as the Chief Executive Officer. There are many mayors, heads of council throughout the province that think that they have a dictatorship, that what they say must rule, and that's just not the case. It's not our system of law. Justice Morocco in the Collingwood Judicial Inquiry agrees with me. The roles and responsibilities of the head of council differ from those of a corporate chief executive officer in a meaningful way. The head of council does not have the same powers as the CEO of a corporation. More specifically, the head of council does not have the power to commit the municipality to anything unilaterally. That's just what I showed you a couple slides ago from the Guelph case. We've had a weak mayor system throughout all of Canada, right? The traditional system is that the head of council is the ostensible head, the leader, but only the leader among equals, only typically has a single vote at council. No member of council, including the mayor, has inherent executive powers and can only act in concert with the quorum of council to implement the decisions made on behalf of council. So now you've got really bad legislation. You've got the Strong Mayors Act, right? I won't pontificate about it. I really think this is bad legislation. I've said so many times. I think I look after 4 municipalities that are strong mayor municipalities, and I haven't hesitated to say that in a public session when I've gone to speak about this. I think it's really atrocious legislation. However, it's there. It doesn't apply to this municipality. But it's not nearly as broad the powers as people think it is. Many strong mayors will take the position, I'm a strong mayor, I can speak to anyone however I want, and I can direct staff to do anything that I want. That's not the case. It's just not the case, even with a strong mayor municipality. Now, let's talk about the individual members of council. Unlike other players in the municipal context, there is no statutory provision that actually speaks to the role of an individual member of council. The Ministry of Municipal Affairs and Housing, every 4 years, does a nice little, it used to be a booklet, now it's just on the website. It says the role of the councillor has 3 main roles: a representative, policymaker, and steward. I would probably change the last word to trustee, but it's pretty much the same thing, right? These roles often overlap. George Rustive, very well-known lawyer in Ontario, who just handed in his license a couple of years ago. Members of council have no authority as individuals to take action on behalf of municipal corporations, except at the council table, when you're acting as a part of an elected assembly and you're making decisions with a majority of the other members of council. That's where your authority resides. You also have fiduciary duties. This case is, I think, from Thunder Bay or Sault Ste. Marie, I can't remember. Elected official stands in a fiduciary relationship with the electorate. What is a fiduciary relationship? You have a duty of care, you have a duty of loyalty, you have to act in good faith, and you have to maintain confidential information as confidential, okay? You're not employees. I thought this was very clear, but if you look at the second case on the slide, Raz versus City of Mississauga and Ron Starr, that's the sort of infamous case where Karen Raz resigned from City of Mississauga, said that she was being harassed, bullied, and intimidated by a member of council. Member of council, I think, was Ron Starr, who had keyed her car. We acted for the integrity commissioner in that matter. There was a judicial review application brought that never came to court because he backed down. But Karen Raz then went to court saying, hey, Mississauga had to protect me because I'm an employee of the municipality. You're not. The Occupational Health and Safety Act does not protect you as a member of council. However, it does work the other way. It's a burden, but not a benefit. You're not employees of the municipality. So let's just switch now. Let's talk about the municipal administration. I've talked about council, the head of council, and members of council. Municipal administration, it is articulated. It's in section 227. What do? Implement council's decisions, carry out council's decisions in implementing policies, undertake research and provide advice to council, and carry out duties as assigned under the Act and by the municipality. And who's the decision maker for the municipality? Council. Staff is there to work for you. Why do so many members feel that staff is only trying to stymie what they want to do? I don't understand that. I keep getting this. I've been doing a lot of midterm refresher courses, presentations for councils. And I keep getting this. I keep getting that staff is not being respected. So let's just think about it. This was a major, major concern in the Collingwood judicial inquiry, right? Because staff were being directed by the head of council, the deputy mayor, and the CAO to do things that the rest of council did not even know about, and in some cases had actually decided to do something not what they wanted to do. Justice Morocco says municipal staff are imperative to the functioning of the town. Amen, I say. That's true. You can't not work as just the governance arm, right? What is council? Council's the governance arm. What is staff? Staff is the administrative arm. What's the governance arm do? You make executive decisions. You make legislative decisions. What does staff do? Staff carry out the day-to-day management and operations of the municipality. And the two don't really, or shouldn't really, mix. So I'm going to get to that now. There are statutory officers. I won't spend a lot of time. And you see I've grayed out two of them because typically I use this slide for local municipalities, but you're an upper tier, and so I don't think you have a fire chief. No. And you don't have a building official because it's at the local level. But you have a clerk, treasurer, auditor, and you also have a chief administrative officer. Once you have those officers, you've assigned to them, and they've been imbued by certain statutory responsibilities that they are required to carry out. So, Matthew, I'm going to just pick on you now for a second. The chief administrative officer, not a mandatory officer. All of the other ones on there are mandatory officers. You're not a mandatory officer. However, if council makes a decision to appoint you as the chief administrative officer of the municipality, you are responsible for the day-to-day operation and management of the municipality, and in what form? To carry it out effectively and efficiently. It's not council's responsibility to do that. Many councils don't understand that. Many members don't understand that, right? So, members of council must also, this is getting to the point, must also respect the need for a neutral and impartial public service. Why? Because staff, they're the professionals. They're the persons who have been put in place, some of them with professional designations. Professional planner, potentially, an accountant, a lawyer, a licensed lawyer. I'm trying to think of other professions, but there are other ones, right? They have professional designations. They have professional responsibilities, typically codes of conduct for their own professional obligations, like I would as a lawyer. They give their best advice, ready for it, based on the merits of the question before it. Justice Morocco did not decide that staff give their best advice based on what the political expediency or where the political winds may blow that day. I'm being very blunt with you. Staff are there, they're professionals, they're qualified, and it would be wrong to accept persons coming forward and saying, I disagree with the staff report, they're completely wrong. First of all, even if they do have professional qualifications and they may be able to even make that statement, Why would you not trust your staff to consider that you put them in place? There was a hiring process, there were qualifications for those senior members, and they have the same fiduciary duties that you as members of council have to the corporation and to the electorate. A senior member of staff is a fiduciary. Many people don't even recognize that. So, how do these things work together? Council's role is to make decisions on policy and to make broad-based rules on how to govern the municipality on matters within its jurisdiction. Staff carry out those policies and ensure that the bylaws are enforced, made known, and so on, right? Here is a really great quote. I didn't have this. I found it the other day. I'm very embarrassed to find that it was from 2008. I'm going to read it to you in full. I know you can read it, but it's important. The political power held by councils and committees is, in the main, a policy-making role. Mayors and municipal councils represent the public by holding delegated authority to pass bylaws, determine broad questions of policy, including the allocation of municipal programs and services. They also establish and oversee administrative policies, practices, and programs that are required to implement the decisions of council. Right? That's a lot of power. It's the governance power. It's the executive legislative powers. By contrast, councillors are not given the power to do the hands-on administration of a municipality. It is the officers and employees of the municipality who implement or administer council's policies and program choices and carry out the duties assigned by the municipality. I used to bring up the Zamboni incident to give the example of this. I've now modified it because last term of council, I have one council we act as integrity commissioner for, and I will disclose that they are an island in Ontario, so it's going to narrow it down. Member of council at this municipality had a historical problem with the ferry that used to take people from the mainland to the island. Right? You probably know where I'm going with this, right? Historically, spoke at council, spoke very strongly about it, did not like anything to do with the ferry. One day, it was a cold November day. Everyone was freezing on the ferry, waiting for the ferry captain to come on board. Ferry captain's nowhere to be seen. Maybe the ferry captain wasn't feeling so well. Don't know. Council member was on board the ferry. What do you not do in that case? You don't take over as the captain of the ferry. That's what he did. What could that do? Injury, death, liability, and total disrespect of the person who's supposed to be carrying out. We reviewed this as integrity commissioners, and we said that's completely wrong. You just can't do that. You can't take over the role of the council, of the staff. Another incident very recently that we had to look at, member of council was very upset, did not like the fact that the cupboards in the locker room did not look very steady. Decided he was going to go and fix it. What happened? Someone hit it with a ski. It fell down. That's liability. He had no authority to go in there, start doing the carpentry work himself. What should you do? You should go follow whatever procedures that you have at the municipality for notifying the proper staff member, okay? So.
John, I'm just
yes.
going to jump in and say, and I know you've got a few slides, we've also got some questions piling up, so...
Yes, okay. Madam Mayor, how am I doing? I'm not doing so great with time, am I? So I'm going to speed it up a little bit, so I'll leave some time for questions.
Thanks.
So, I like this quote. It's from 3 academics, but Joe Kustner was a council member in St. Catharines. I love Joe. He's my council member for years. The prescriptive literature offers clear, if not always attainable advice. Politicians must take a clear leadership role in policy setting and stay out of administration and management. Now, respect for members of staff. This is the case. Villeneuve, what happened in this case? Public meeting. There had been contention between the member of council, Roxanne Villeneuve, and the CAO. She had sent a number of what the Integrity Commissioner claimed intemperately worded emails to him. At council, she said, "Why aren't you telling us the truth?" Basically calling him a liar in an open council meeting. The Integrity Commissioner looked at it. The Integrity Commissioner went away, said, "You can't do this. You're not showing respect. It doesn't comply with the council staff relation policy. I'm recommending a significant penalty." Council agreed. Councilor Villeneuve felt that she would hire a very strong-willed lawyer. She did, Ron Caza. I've been up against him. Yes, he's very strong. He argued this case. The court came back and said, look at what the requirements are for code of conduct. Respect for staff, right? What does the code say? It enshrines this. And you have a policy that says how council and staff have to work together, council-staff relation policy. The court came back and said, yeah, the Integrity Commissioner's decision was reasonable in this, and said the relative power imbalance between staff who do not have a voice at council unless they're asked to, and elected members who do, mean that their respective roles and responsibilities must be acknowledged and respected. So you will see this in the code coming forward. So there's the council-staff relationship policy. By the way, I think we've drafted that as well, right, Tim? For you? Okay. So we have that coming forward for you. Okay. There it is. It's right in your code. So I won't belabor this. It's on the slides. So I'm going to, Madam Chair, I'm going to distill the next number of slides down really quickly to this. As a member of council, you probably have multiple roles that you have to fulfill. You're probably on committees, right? And a number of you are mayors. So you sit as mayors on county. So you have two roles. Now, I've said right at the beginning, as a member of council, you have to look out for the best interest of the municipality, the electorate, right? The corporation. What happens when you have two hats on? You're a local member of council, but you're also sitting on regional council. What do you do? Well, there are rules about this. So let me come down to this. To whom do you owe your fiduciary duty? The general rule is this: the primary obligation of a member is to act in the best interests of the body in which they're asked to make a decision or ruling at the time that they're sitting on it. The sub-rule to this is how I interpret it. If you're a member of council here, I'm speaking to you mayors, your municipality may have taken a very strong view on something. They may have voted unanimously at the local level. When you come to regional council, do you represent your local municipality? You do, because you're elected here to be the representative. But whose best interest do you look out for? And if you just say the municipality of which I was elected, you're wrong. You look out for everyone within the entire region. So this leads to some interesting, brain twisting sometimes. How do I deal with this? The way I look at it is you cannot only act in accordance with what the dictates are, what the resolution may be, or the wishes of your local council. You have to consider your role as a regional representative and your role there. I'm going to give you one example. I was about to say this to Witchard-Stouffville Council, and the mayor interrupted me. He said, "John, can I give the example?" I said, "Absolutely, Mayor Lovett." He says, "I'm a member of regional council, York Region, but I'm also a member here." We were talking about service levels. We run at the region, York Region Transit. We have one route that goes through Witchard-Stouffville. It is the most important bus route that we have because it takes people all the way to Yonge Street. It's imperative for my municipality to have this. But at regional council, I had to make a decision. It was one of the lowest serviced bus routes in the entire region of York. So he said, I voted to cut it. And I said, that must have gotten you a lot of applause back at council. He said, absolutely not. I go, those are the tough decisions that you have to make. So you can't come here and say, I'm only going to act in accordance with what Cambridge wants or what Wilmot wants or what any of the other local, Kitchener, Waterloo, any of the other municipalities want. You have to put on your regional hat and say, how do I think about all the people in the region, right? And I believe you have some issues on just that topic. So I'm not going to go through this, but I want to show you Walker. Walker is a case where 3 members of City of Toronto Council were appointed to Toronto Harbour Commission. And June Rowlands at the time was very clear. She's actually quoted in here, or cited, where she said, you have to act as the city tells you to act. So here's the quote. The applicants, the City of Toronto councillors on Toronto Harbour Commission, they are acting in the best interests of the Harbour Commission. It would appear that Mayor June Rowlands believes that the city-appointed commissioners should only act in a way representing the interests of the city. If she believes this to be the case, she is in error. Look at the boldface. The members thereof must act in the best interests of the THC, regardless of who appointed them, even if that interest is contrary to the wishes who appointed them. Otherwise, you're coming to regional council and you're abdicating your responsibilities. You have to make the decisions here as a regional councillor. So, Madam Chair, I've come to my conclusions. Regional Council, the governing and policy setting body, making the decisions. The administration, management and operations. Council's decision-making authority for the municipality. Municipal councillor is part of a collected assembly, part of a collective body. Has to always act in the public interest, cannot fetter his or her discretion, their discretion. No individual executive or ministerial powers, must comply with the resolutions, policies, rules that are put in place by council from time to time. We met a lot of these during the COVID matter. The executive branch must work together with the administrative operational branch. My final slide, didn't show you my final slide. My final slide was actually, I thought, I must have deleted it, was the full quote from the Ministry of Municipal Affairs and Housing, which ended up saying, you are not only elected for a 4-year, you are elected for a 4-year term, but you cannot make your decisions on a 4-year term horizon. You must make your decisions based on the long-term policies, strategies, master plans that the municipalities put in place. Staff, are staff here for a 4-year term? They're not. Many of them believe that if they do a good and proper job and they're professionals and they give you neutral, impartial, objective advice, they will be here for the long term. I bet a lot of your staff would like to be those people that stay with one employer or maybe the second employer for a long term. They may tell you sometimes, council, that's the wrong decision to make. Do you think that they really want to tell you that? Wouldn't the easiest thing be, yeah, we'll do what you want? They would be abdicating their responsibilities. There's a tension there because sometimes there's a misalignment. You have to respect that. Madam Chair, that's the end of my formal presentation. I'm happy to take any questions.
John, thank you. It was very engaging, very informative. I'll go to Councillor Hunick.
Thank you, Chair. Thank you for that excellent informative presentation and your insights. Do you know if our code of conduct has anything to say about implicating community organizations in the public setting of a council meeting? I'm not only conscious of the political power that we have here, but also the influence that we have over the community's perception.
Thank you. Through you, Madam Chair, that's an excellent question. It certainly speaks to being proper and respectful of all bodies. I'd have to probably know a little bit more about what, and probably more than just this meeting here, about what implicating, people from the public may mean, because I'm not sure I can answer that very simply and succinctly right now.
That's okay. Perhaps I can email you offline and get more clarity there. I have a more specific question for you, if that's all right, and hopefully it'll be an easier one. On what grounds would the chair, she's a nice lady, I don't think this happens very often, but on what grounds would the chair have authority to expel a member of council from council, as you stated?
Yeah. So through you, Madam Chair, you'll be interested to hear about this. The chair has the authority to do that. There's no standard that's actually put in the Municipal Act. It's the determination of the chair. The chair does not actually have to go and ask anyone for permission to do so. My view is chairs typically will only exercise that in the most extreme circumstances. You probably have heard about it, and yes, we have some involvement. The town of Whitby, what happened there. By the way, there was no expulsion in that case. The mayor called a recess. Let's have cooler heads prevail. Typically, that's what I find. Let's just have a deferral. Let's just adjourn, right? Let's stand down for now. But yes, it's the chair's responsibility to make that decision, and no one can challenge that. Thank you, Councillor.
Great question, Councillor Hunick. Councillor Foxton.
Thank you, and through chair, excellent presentation, but it's black and white.
Thank you very
Which is all pop, and all things are supposed to be like this, black and white. And as I say at my council, staff follow the letter of the law. Council takes the information, discusses it, and asks it to be tweeted at times. But staff follow the letter of the law. What if you feel a staff report is not complete enough, or you have questions? We have every right to ask those questions. Is that correct?
Yeah, through you, Madam Chair, to Councillor Foxton, absolutely you do. Please don't think I ever said that you can't question. You can question, you can ask questions, you can seek clarification, you must do it in a respectful manner. I often see things like there's a professional opinion given and someone will blurt out that's entirely wrong. I mean, first of all, it's just not proper decorum, but you know, you're questioning someone's professional capacity. But yes, let me be very clear. Of course, that's your role. You get the information and you're allowed to ask questions of staff. Then the question becomes, are you allowed to cross-examine them? I'd say no, you don't cross-examine them. And if you have a concern, then maybe it's privately raised in an in-camera meeting. For instance, I don't know this, but you know, you have a question and you really just don't think you agree with advice, professional advice that's been given by one staff member. Potentially what you want to do is raise that with counsel in a closed setting, which you can do under 239(2)B, personal matters of an identifiable individual. You don't want to call out the staff member or embarrass them, because what are they supposed to do? They can't respond back. They can answer potentially, but they could be, they're at a power disadvantage, just like I showed you in the Villeneuve case. So yes, you can ask questions. Of course you can.
And not just questions, but you can also thank them for the report, but make changes to the report. That's the right of council as well, to make amendments to the report as well. We do not, the staff can present certain things based on certain criteria, but we can also add different criteria. What I'm saying is there has to be a two-way dialogue. Council, if we only follow the letter of the law by staff, you don't need council.
Well, council's the decision-making body, so I think you still need council. Council has to approve it. But let me just go back to your question. You change reports. I disagree with that. The report's written by staff. It's administrative reports written by staff. You can ask for clarification. You can ask staff to reconsider something. But I don't know that council has the authority to go in and change the report.
No, not change the report, but reconsider something. You're right. And
Yeah.
we do make amendments. Quite often we make amendments to certain motions in regards to certain reports.
Oh, absolutely. I'm sorry, through you, Madam Chair. Yes, of course you can make comments, change the motion, you can change the recommendation. The recommendations are just recommendations. That's for council. And of course you can change that. But I'll give you my example. I'm reporting to council as a lawyer. My main role is not as an integrity commissioner. Just to be clear, I am a municipal lawyer. I've been doing that for 35 years. I will give my opinion to council. My opinion is my opinion. Council may say, are you positive about your opinion? I can say, oh, maybe I need to reconsider. Maybe I need to look at something. I did not know that. Let me look at it. But they can't change my opinion. They can change my recommendation. My recommendation is, council, you should settle this. Council goes, nope, we don't want to settle it. And I fully respect that. But don't come in on my opinion. Don't then disparage my opinion like Mascarin doesn't know what he's talking about. That's entirely wrong. Actually, you could say that to me. That's okay. I'm not in-house staff, which is very different. I probably, I can let things roll. I'm not here every day, but to do something like that to your staff would be wrong. You can't get Fiona McRae to change her opinion. Sorry, you can't demand that she change her opinion. She could change her opinion if she believes that she can change her opinion if she's relooked at something, but council can't change that. I hope, I'm trying to be as clear as I
No,
can.
and totally, and I'm trying to say respect for all.
Yeah.
Including councillors.
Yeah.
And councillors may not agree on a decision, and that's okay too.
Yeah, so let me be really clear. I'm sorry, you didn't really ask, you were making a comment. I totally agree with you. Staff should have respect for the council and council's role as the governance arm. And sometimes council will disagree with the staff report. That's fine. I think that's absolutely fine. And I'm prepared to accept that. I give advice all the time. Not all of it's followed, but I'm not going to hold a grudge against it. Yeah.
Thank you very much.
Councillor Erb.
Thanks, Chair Redmond, and thanks very much for an informative report. I'm wanting to go back to the, I think I understood that our bylaw is specifically mentions 9 days before that we have till a decision is made. Is that what you said?
To be clear, yeah, Councillor Erb, to answer your question, I believe it says you can make a decision up to 90 days. I think, I'm not sure. I haven't looked at it recently. I've been looking at the amendments or the new code that we're putting forward. I thought there was a provision in there that gave you that much of a period of time to make a decision.
Is that right, Mr. Clerk? Or?
Yeah, that's my understanding. Mr. Mascarin is correct, and that's one of the things that needs to be updated when we look at our policy.
So is there a best past due date kind of a thing that like if you don't make a decision in a certain time, it's an invalid decision?
That's really interesting. Just the other day, I was asked for a legal opinion on just this. A lawyer reached out to me and said, our council, the council seems to continue to defer this matter without a definite date on which the decision can be made. Can they actually do that? And I go, well, one of the responsibilities is they have to make the decision. I said, to defer something indefinitely and not bring it forward is basically to say no to it. As you know, under the Planning Act, if you do this, it's a non-decision and there's a right of appeal. So I think that's almost what you're asking, Councillor Erb, is like, does something like that work? No, but someone I think could file a judicial review to say the council's failure to make a decision is a non-decision and we're going to just go to court, or file a complaint with the Ontario Ombudsman.
Councillor Craig.
Just very quickly on conflict of interest. If a councillor promotes let's say a park across from where he lives, talks to people and staff about that, and then comes to council and declares a conflict, when is he actually in conflict?
Right. So, through you, Madam Chair, so just to get, when you say promote the park, what do you mean? To promote the establishment of a park there?
Well, as opposed to putting it in some other part of town,
Okay.
that sort of thing, which is, right, and then that individual decides that across the street from his house, that would be the best place, talks to the community about it, and then declares a conflict at the table. When does conflict come into play?
Yeah, that's Councillor Craig, that's a really fascinating question, and it's very nuanced. The cases, I'll be honest, are a little bit all over the place on that. Okay. There are cases that say the potential for the pecuniary interest must exist on the date, on certain dates when the matter is being considered in council. But if you look at section 51C of the Municipal Conflict of Interest Act, it says if you're at a meeting and there is a matter for consideration at the meeting, you must declare it, and then it has a couple of recusals. One is you cannot participate or vote on the matter. But the next one is the problematic one. It says you cannot seek to influence the vote in any way before, during, or after. So, going back, and I'm going to cite a case from about 12 years ago, Mondu and Tuckenhagen from Thunder Bay, where a council member had formed an opinion that they wanted to purchase a property. Then went and spoke to staff about, are you interested in selling this property and so on. And the decision of the divisional court said, he formed a decision that crystallized the pecuniary interest, and therefore he had the pecuniary interest. He should never have talked to staff, and he was in a conflict position. I'll be honest, I found that extraordinary, but it's the Ontario Divisional Court, which is the highest court you can go to on a conflict of interest matter. And so it resides. And I always say to people, be very careful. If you know that you have a potential pecuniary interest, if you start talking to people, someone's going to come and say, but I heard about this 2 years ago. And now he's declaring a pecuniary interest, but he's interested in this park. So it's a really, really difficult decision that the Integrity Commissioner has to make at that point, or the court has to make. My view is you should really stick away from something like a park, or don't have that landfill right there, right? Because if you're going and speaking to it, that might be a problem. Someone will say, well, he was trying to influence the vote 2 years before the matter even came to council. I think that's a little silly, but I think the case law doesn't help members of council on that.
Okay, thank you very much.
See, John, I didn't say there would be easy questions. I'm going to go back to Councillor Hunick. I see no other questioners, and then we will wrap this up. Councillor Hunick.
I just have a quick question of clarification for Councillor Erb. I wasn't sure if you said 9 or 90 in terms of the number of days.
Yeah, I thought it was 90.
9-0.
Perfect.
9-0, yeah,
I-
which is an incredibly long period of time, not 9 days. If it was 9 days, you'd have to call a council meeting very soon,
Okay.
right after.
So, John, I want to thank you very much for this presentation, for this education, for continuing to be our integrity commissioner and help us work on our policy. I know we'll see you again and again.
Yep.
If any council member ever has a question, you can proactively reach out to John to clarify the way forward. So, John, thank you very much again.
Madam Chair, thank you. Council, thank you very much. I'm sorry I've gone a little long. I will help out staff again, and you may see me and you may have more questions when the code comes forward. By the way, just the last comment, if you have questions, please remember you must put them in writing. That's what the Municipal Act requires. And it's not just, hey, John, can I speak to you tomorrow? It's, here's the fact situation, here's the report. So I know you guys have actually been, members of council have been very, very good about that, but I just want to remind you of that. So thank you again, Madam Chair and Council, for this afternoon. I really appreciated the opportunity.
Thank you very much. Appreciate you came in. Colleagues, I would now entertain a motion to go into close. There are 6 points why we will go into close. Moved by Councillor Wolf, seconded by Councillor Williams. Please use your e-scribe to vote. Councillor Shantz, if you're, Councillor Harris, if you're online, if you could vote. Thank you, colleagues. I will now entertain a motion to adjourn. We will go down to the Waterloo room for our closed special council meeting. And so now I need a motion to adjourn. Moved by Councillor Foxton, seconded by Councillor Nowak. Please use your e-scribe to vote. Chantal, you never want to adjourn.